Welcome back to I Want a Real Lawyer. I pretty much called it. I did not think the judge obviously disagrees with me in this case. The judge presiding over the Diddy freak off trial was hoping to have jury selection wrapped up today, and I said that was not going to happen. Despite the pretrial publicity that this case has garnered, we have to consider the fact that Sean Diddy Combs is a mogul. He was once upon a time. I guess some people might argue they still is. But based on that alone and the Cassie video and social media, definitely social media, there's no way the court could have impaneled a jury by today. I thought it was too soon, and obviously that thought panned out to be accurate. Court will be back in session. Court will reconvene on Friday. The judge is hoping to wrap up jury selection then and actually impanel a jury, 12 jurors, 6 alternates. I just want to recap the day as is reported by USA Today as well as the New York Post. All right. By the end of the court proceedings today, the court or the attorneys had pretty much narrowed down potential jurors to 45 individuals. Okay. And that process will proceed further, or voir dire will proceed further on Friday. As is to be expected in a trial of this nature, potential jurors were repeatedly questioned about whether they had family members or friends that had been victims of sexual assault, sexual harassment, or domestic violence, or whether they themselves or loved ones had been charged or accused with crimes of this nature. At this juncture, 6 women and 5 men are part of the jury. They have been impaneled as jurors. That makeup is pretty interesting. And immediately when I got a sense of the gender divide, or rather the makeup of the jury, it's not everything, but it could signal one way or another. These 6 women and 5 men were impaneled because the court and the attorneys are satisfied that these individuals are impartial and they will give this case their undivided attention. But based on the allegations in this case, again, with the 6 women, 5 men, we don't exactly know who will be part of the deliberating jurors and who the alternates will be. In a case such as Diddy's, though, if this was my case, from the perspective of a defense attorney or public defender, you probably want more men on the jury. But from the perspective of the prosecutors, they most likely want more women. I don't want to chalk it down to emotions per se, but the allegations here are certainly the type that will evoke certain emotions in not just potential jurors, even the ordinary spectator, right? People have formed opinions as to Diddy's guilt or innocence. I think, without a doubt, I do think that the genders of the folks that will be deliberating will play a role. I do not know that the identities or genders alone will carry the day. And talking about gender, it's very interesting in this case that the prosecution team consists of women. From my perspective, I do think that that is most likely deliberate, but then again, it just depends. I think the genders of the prosecuting attorneys in this case is interesting, and maybe interesting is not the right word to use, but it is from my perspective, I think it is tactical. And not to say that, the unit that they work in does not have men that also prosecute cases of this nature, but I would like to believe that having an all women's prosecution team is tactical as far as it goes to not so much, I don't want to say playing into the jury. As far as the impaneled jurors thus far, their ages range from mid 20s to early 70s. The group is said to represent a varied cross section of New York City, with one juror working as a graphic designer, another in administration at the Counterterrorism Office of the United Nations. Let us take a closer look at some of the potential jurors in this case. As I've previously stated, this case has generated a lot of pretrial publicity, and social media definitely plays into it. It is being reported that a potential juror was questioned about their social media habits. The defense referenced a meme that they implied the potential juror may have interacted with on social media, but the juror chalked this up to be doom scrolling and mindlessly swiping. When the judge asked this potential juror if they may have seen things that might have made them biased against Sean Combs, their response was no. In a plot twist, this potential juror went to the same high school as Diddy, though they graduated 30 years apart. Probably the most interesting potential juror I've read about thus far has to be the sleep deprived juror. This potential was reportedly questioned for about 25 minutes, and throughout, this individual sighed and trailed off in his speech. Okay, the judge noted that the man neglected to fill out the questions on the juror questionnaire. Listen, whether you're prosecution or defense, this is not the type of person you want, and here's why. Unless, of course, let me take that back. It depends on the type of. Because I'm trying to justify it from a defense perspective where the defense has very little to do with the law, or where you're hoping for, you don't want somebody that's not paying attention. You no. Because I was trying to see if maybe there could be a benefit to a Sean Combs wanting this individual on the jury, but that's a no. That has to be a hard no, because you do actually want somebody that's going to listen and follow instructions, even if you have no real defense. And I'm not saying that Diddy has no real defense. That is just me generalizing. I've read the indictment. I am aware of Diddy's defense in this case. He is arguing that these interactions or relationships, the freak offs, were consensual. He's alleging that the alleged victims in this case are disgruntled ex-girlfriends. My issue is, again, it just depends on the case. My issue, again, if I am defending a criminal defendant in a very difficult case, my job is to make it as difficult for the prosecution to secure a conviction. So I'm going to want you to prove up everything. I suppose there's a benefit to this defense in the sense that Diddy cannot deny actually having interacted with these women. And I suppose from a defense perspective, it makes sense for them to concede to at least part of the allegations, or at least concede to some form of familiar relationship between these individuals. The defense is still kind of I'm not sure about it. I'm not exactly, again, we did not even get to opening statements yet, so I question what the possible evidence is going to show from a defense perspective. Again, defense does not, they don't have a duty to prove or disprove anything, but with a defense like this, it kind of has to be one that is believable. And the other problem with this type of defense is because there is such a thing. I remember, when was it? Oh, many years ago. Many years ago. I don't even think I was a parent yet, but I was somewhere in Mississippi, and I was having a discussion with a really, it was an elderly woman. Okay, my mother-in-law and I were having a discussion about, it was not not even really a discussion. She just asked me a question. She was like, she asked me a question about whether a man can she asked me a question about whether a man can rape his wife. And I was like, yeah, that is the law. Men cannot just, even if you're married, you cannot just force yourself upon somebody. So that's my issue with the defense, because a certain, sure, maybe Diddy was in fact in relationships with all 4 or 5 of these women. Let me think back. I think the number's 4. I think it's 4, if I'm not mistaken. The victims that I expected to testify in this case. Fair enough. Maybe they were in fact in relationships, or he was with 4 women, or in a relationship with 4 women during overlapping times. Even if he was in a relationship with them, even if he was married to them, let us assume if he was married to all of them or one, I mean, that's a crime, but you catch my drift. You can still be charged for forcing yourself upon somebody. So that's my struggle with the defense. Okay. In any event, let's get back to the sleep deprived potential juror. So the potential juror was sighing and he trailed off in speech, and he neglected to fill out the questions on his juror questionnaire. I guess he wanted nothing to, it sounds to me, it sounds like he wanted nothing to do with this trial, and he was hoping to not get selected. Now we're gonna go back. Okay, I'm getting distracted, but let me think of the county. Must have been somewhere near Albany. Okay, must have been somewhere near Albany. But there's a judge. There's a judge that had to vacate his office because he came up with a really silly excuse in order, or in an attempt to be excused from jury duty. If I'm not mistaken, I believe I'll have to go find it. I'd planned on making a video about it like many months ago on sustained overruled, but life got busy. In any event, so this judge during voir dire, I believe he said something along the lines of he believed that all criminal defendants were guilty or something along those lines. That's a big no-no for somebody that works in, or somebody that holds office as he did, and information became public and he had to vacate his office. Again, under these circumstances, I don't know if the sleep deprived juror was in fact just exhausted and tired, or if this was an excuse. I don't know. I wasn't there and I'm not him or her. Anyways, let's move on. So when this potential juror was questioned by either the attorneys or the judge, he responded that he was tired because he was binge watching the new Star Wars, okay, the series, and it had just came out. Apparently the judge laughed at this potential juror's admission and asked him if he would be able to concentrate, or if they would be too busy binge watching the Star Wars series. And the potential juror said he would, responding, like I said, I was binging, I'm just being lazy. So well, I guess he's honest. I don't even know what to make of that. Okay, so while the prosecutor said that this potential juror was meandering and they were worried about his own personal discipline if he was selected for the trial, the judge said that none of his answers warranted a dismissal. And it turns out that it's the judge that actually dubbed this potential juror sleep deprived. During the first part of this video, I kept going back and forth about whether a defendant would want a sleep deprived potential juror or even impaneled juror. I guess we have an answer. All right. So Diddy's lawyer, Agnifilo, offered his opinion on the matter by basically saying that he's very curious to watch what this potential juror was binging. So it seems like he had no real issue with this potential juror serving. Here's my thing though. The reason why I'm struggling with this, whether I would be on board with having a sleep deprived juror, my biggest problem is that an individual that is not, again, maybe in his defense or her defense, maybe this potential juror will only be sleep deprived up until the trial commences, and then there'd be all I don't know. My biggest issue is whether this potential juror could be influenced. What I mean by that is if they are not following the trial on their own, not making up their minds on their own, then they do stand the chance of being influenced by other folks, especially for individuals that may at the conclusion of the trial, individuals that are of the opinion that Diddy is guilty of the charges that he's accused of. Let us move on. All right, and here's another interesting one. So one potential juror actually knows the judge that's presiding over the Diddy case. It turns out that they've known each other for about 10 years, and they were co-counsels on a number of cases. And that is common for New York. I don't find that out of the ordinary because if we go back to the Orange Ones trial, I believe there were two attorneys. I believe there were two attorneys on that jury. So the prosecutors in this case, they were worried that the potential juror, that's an attorney that knows the presiding judge in this case, a lot of words I know, would influence the other jurors because of his position. And for that reason, the potential juror was dismissed. That absolutely makes sense. It makes sense because said potential juror worked, to me, it sounds like he worked as a defense attorney in criminal cases. That's a huge influence. Going back to pre-trial publicity in this case. So one potential juror said that she had seen footage released by CNN of Diddy allegedly assaulting his ex-girlfriend, Cassie Ventura, and that she felt he would be guilty of domestic violence. When the judge reminded her that the charges against Combs in this case are not domestic violence, she said that she would aim to judge people on what they actually did and that she would want to hear the whole story behind the video. Listen, if I am a defense attorney on this case, I'm using my peremptory strike and I'm removing her. I'm not taking chances, not taking chances. So apparently, as lawyers pretty much zeroed in on her ability to be impartial, she raised eyebrows among spectators because she seemed to walk back her earlier sentiments. And this potential juror voiced that she thinks people tend to jump on the bandwagon to say something bad has happened to them. And apparent reference to the lawsuits brought against Diddy in the wake of his federal indictment. Listen, if I am defense attorney, I am using my peremptory strike. I do not want this potential juror anywhere near the impaneled jurors. Nowhere near. Because she's pretty much already voiced what her sentiments are, despite later on saying that she could be impartial. So we have a big one here. So USA Today reported that a lawyer close to the Diddy defense team was admonished by the judge for referring to the prosecutors in this case as a six-pack of white women. These are comments that were made on a podcast. So the lawyer Mark Giragos appeared on Two Angry Men, which is a podcast that he co-hosts with TMZ founder Harvey Levin. Mark apparently said that race would be an undercurrent at the trial, but that would not be the focus of Diddy's defense. And according to USA Today, the judge told Mark in a private conversation, this is according to a transcript, okay? These are the words. That's something that no one should be saying as an officer of a court and a member of the bar. The judge went on to say that referring to the prosecution in this case as a six-pack of white women is outrageous. I would not have phrased it that way. But I do think that having a team that consists of all women, I think that was intentional. It is just as intentional as having a female attorney cross-examine Amber Heard in the Johnny Depp v. Amber Heard trial. So I do not know that there's anything nefarious, unethical, or improper about the composition of the prosecution's team. And then, so Mark is not, just to set the record straight, Mark is not one of Diddy's lawyers, but his daughter is a part of the defense team. Apparently, the prosecution has taken issue with Mark. I keep calling him Giragos. listen, I'm probably butchering this man's name at this point. I'm just out here butchering people's names. In any event, the prosecution has taken issue with his presence in the courtroom because apparently he is a permanent fixture in the courtroom, despite him not actually being a part of Diddy's legal team. So that sums up jury selection thus far. Okay, I think the biggest blow, however, what could potentially blow being hyperbole. All right, I speak in hyperbole, but there's a potential problem with the prosecution's case. So the prosecutors admitted to the court today that they may have to proceed without a key witness. So this woman is expected to testify that Diddy coerced her into sexual acts in line with the indictment. So the prosecutors admitted in court today that they've been having trouble locating this witness or getting in contact with her lawyer, and that this individual was dealing with undisclosed personal issues. So one of the prosecutors pretty much told the court that we do not know whether she intends to appear. We're trying very hard to find out because we're having trouble communicating with her counsel. Apparently, this victim or witness does not live locally, so I suppose I don't know if that's in the borough or if that's the state or the county. The prosecution did, however, signal to the court that this individual might not show up even if they try to enforce the subpoena or if they wanted or even if they wanted to call her. So here's another issue. Again, earlier on, the prosecution is saying that this individual has been dealing with undisclosed personal issues. Okay, so here's another issue with this potential witness. It was revealed that the accuser planned to use her real name during her testimony as opposed to a pseudonym that she had previously asked to use. I guess we'll find out on Friday. We'll find out on Friday if this witness will be testifying at all. And here's the thing. It's not exactly a blow to the prosecution because they do have two or three other no, they have three other witnesses that will be testifying to the allegations in the indictment. I do not exactly know that this is, in fact, a blow to the prosecution in the sense that there are three other absent any shockers or surprises or other forms of unavailability of witnesses. The prosecution expects to call three other witnesses or victims that are going to testify to the underlying facts. Okay, and then a fifth accuser will be allowed to testify in court, even though the defendant is not specifically charged with any crimes related to her, but her account mirrors the coerced sex accusations of the other victims, according to a ruling that the judge made. The court expects for jury selection to cap off on Friday, and if that's in fact the case, then we're at 11 right now, so that there's a good possibility that we have a jury by Friday, the 12 jurors, 6 alternates. So if that's in fact the case, then opening statements are expected on Monday. Opening statements, important part of the proceedings because that's a roadmap for the prosecution and the defense. And I typically, most of the cases that I cover, I tend to focus more so on the prosecution as opposed to the defense. But I still continue to question the defense in this case, the defense, more so the defense that they raised. And now my mind is just racing because I'm thinking about Judge McBurney in a sense. I'm thinking about the last trial that I watched in his courtroom. I'm trying to remember what that defense was. Was the defense consent or not? I don't remember. In any event, I do question the defense raised in this case. But again, my hope is that during opening statements, we get a clearer picture as to what the defense could potentially be arguing in this this case. In any event, we're definitely going to find out more about the victims or alleged victims in this case. I do not know exactly because, again, in order for Diddy is arguing that he had consensual relationships with these women, okay? Based on those allegations, I would like to assume that he knows something about these women. The problem is, though, with sexual assault cases, there are certain things that a defense attorney cannot get into as far as an alleged victim's character. For instance, I don't know how Diddy plans to execute this defense. He definitely has to call a witness, there's no question about that. I hope he does not get on the stand, and my hope is just in the sense of I do strongly believe in the rights against self-incrimination. Despite the allegations, I still do not think he should take the stand. I will see you guys tonight as we live stream the Karen Reed trial. But I hope you guys have a fantastic day.